I'm Stephen Hamilton. I'm certified in criminal law by the Texas Board of Legal Specialization, practicing criminal defense in Corpus Christi. In Lubbock, Texas, and the South Plains. Defending any Corpus resident, dedicated to defending any Lubbock resident struggling with illegal drug charges. I'm also the author of the book, The Real Consequences of a Texas Drug Conviction. I wrote this book to help Corpus residents understand the law, Lubbock residents and ensure that they know their rights and how they can protect their rights and how to protect their future. You can download a free copy of my book at the end of this video tip. Possession in Texas is defined as having care, custody, control, or management of a controlled substance. So that means that the drugs do not have to physically be on you at the time you are arrested. If it's under your care, it's considered to be yours. Stowing a drug in a storage locker to which you have access, for example, is also considered possession. Simple possession is a term that is frequently used to distinguish possession for one's own personal use from possession with the intent to deliver. Texas law generally views the crime of possession to be less serious than that of possession with intent to deliver. That said, just being in proximity to a drug does not mean you're in possession of the drug. As one Texas court put it, being where the action is does not constitute the crime of possession. So hanging out with drug users who are in your presence does not mean you possess the drug. But if you did in fact use the drug, you can be charged with possession. To prove possession of a controlled substance, the prosecutor must prove beyond a reasonable doubt that you knowingly or intentionally had it in your possession when you were not legally permitted to have it, either through lawful authority or without a valid prescription. Knowingly refers to your state of mind. It means that you must be aware of what you are doing and that it is against the law. The prosecution must prove that the possession was either knowingly or intentionally, but it is not required to prove that it was both knowingly and intentionally. And that's an important point because all that's required is to show that you knew the drug in question was illegal to have, not that you necessarily intended to do anything with it. The penalty for simple possession depends upon the controlled substance involved in the offense and upon the quantity possessed. Most controlled substances are assigned to a penalty group, with the exception of marijuana. If you have been charged with any offense, including a drug offense, download a copy of my book, The Real Consequences of a Texas Drug Conviction, and call my office today so that we can start building the right defense for your case.